Welcome to Georgia Estate Law Explained.
Welcome to the show where we bring clarity to estate and family law in Georgia. I'm Zafia Morales, and I'm here with attorney Stephen Scriber, founder of Scriber Law Group. Each episode, Stephen breaks down the legal issues that matter to most families, from protecting your legacy to planning for life's transitions. If you've ever wondered where to start or how to make the right legal choice for your family, you are in the right place. And today we are going to discuss how to avoid probate. Welcome back, Stephen. I'm so happy to have you here.
Awesome. Happy to be here.
So let's again start with the brass tacks. What is probate and why do so many people try to avoid it?
Oh, yeah. So probate, in short, is the process of getting, if you have a will, of getting that will submitted to a probate court and then having that court certify it as the valid last will and testament of a deceased person, and then appointing the executor named in the will to distribute the estate according to the terms of the will. I'll more broadly say that if someone does not have a will in Georgia, they have to appoint what's called an administrator, who is the person who's responsible for distributing the estate in accordance with the intestacy statute, which just means essentially to distribute the estate to the nearest heirs. So if a married person, a spouse and children, if neither, then parents, then siblings, and until they find their nearest relative. So that's that process as well. But essentially it's the process of going to the probate court and getting the right person put in charge, whether it's a will or not, and then distributing the estate in accordance with Georgia law.
Okay. And what are the drawbacks to just going with the default plan that the state of Georgia has?
Oh my goodness. It can be expensive to get it in place. So let's say even if you have a will, and all your heirs agree to it and everyone's in agreement. Let's say you have a will that, let's say someone's married and has 2 adult children. And the spouse and the children all agree on the probate of the will. You still now have to get the paperwork prepared. You then have to make an appointment, get everything signed, get everyone to sign in front of a notary. Then everyone then has to go. Then the person who's the executor will has to take it to the probate court and file it. Then we have to wait for the judge to approve it, and then submit a bunch of creditor claims, and then all these other hoops. And that's the good scenario.
Right. Let's talk about the really ugly scenario where there's no will at all.
No will at all. So in that scenario, then the best scenario without a will is that all the family members agree on who should be in charge of the estate, and they agree to distribute it. That happens sometimes. The problem with that process, though, is under Georgia law, they get the power to fully administer the estate. It requires 4 weeks of publication, and then everyone to sign off and make appointments. So it probably takes about a couple of months in a good scenario, between filing the paperwork and getting the order and the letters of the administration to be in charge of the estate. And that can be a severe issue for a lot of people if there's like mortgages on houses, bills, other things that have to get done.
And I was thinking just, at the mortuary, trying to get them planted in the ground is going to be
if you don't
really
have the
hard.
cash immediately and the money is in the deceased's bank account, the deceased person's bank account, you might have to wait a while to get it. So then people are scrambling to pay bills. They might be assigning life insurance policies. They might be, God forbid, doing a GoFundMe. So it adds a lot of steps to that. Yeah. And then the more realistic scenario that I would prepare for just no will is that the spouse and the children disagree on who should be in charge, or if there's multiple siblings and let's say the surviving parent had passed, and then it's just a bunch of siblings, and you might be playing out disputes from like childhood in a court stage. Like, I don't want
Dad always loved me better than you.
She always took my candy. Like, she'll take everything else, and then you have to, if someone files the petition, then another child objects, and then you have a whole process of discovery that takes 6 months. So it might be After 6 months, the court may then set it for a hearing. Um, and so we might be talking like 8, 9, 10 months, maybe a year. During COVID, maybe a couple of years before you got in front of a judge to even determine who should be in charge of the estate. And then once that person was in charge, then they have to file a bond, which is like an insurance policy. They have to file inventory returns and stuff like that with the court. I mean, it's one thing to distribute, to give your siblings and stuff updates, but another thing to have to file with the court, and then
Oh
their
yeah.
compliance office has to make sure that's in the right format and you've accounted for everything correctly. And so those kind of things are very, very time consuming. And if you hire a lawyer to do any of those things, it's probably kind of expensive. So
Yeah.
if it was an uncontested will case, like it's not uncommon for an attorney to charge between maybe 2,500, 5,000 to do an uncontested case for a probate. Um, a litigated case, like if you're disputing the validity of the will case or if you're disputing an administrator case, you might as well set a meter like a taxi,
Yeah.
because it just keeps
Oh,
running up and up and up if multiple siblings are paying their attorney an hourly rate. And then there's a good chance in a disputed case where there is no will that the judge will appoint a county administrator who's like a court appointed, typically an attorney, whose job it is just going to be to divide the estate up. And they don't know you, or they obviously didn't know your parent or whoever the family member is. So they're probably just going to sell everything and split and cut a bunch of checks out because they
yeah.
don't have time for your family's drama.
Drama,
Yeah.
exactly. The family drama would cost too much.
Yeah, so
So
it can go
we've
sideways really fast. Yeah,
so we've discussed a few main drawbacks when it comes to time and cost. What
yeah.
about privacy?
Privacy is public record, and in most counties, I'll say in the United States, but in Georgia, in almost we have 159 counties. I'd say safely 100 or more of them. You can go onto a website and pull up any probate record you want.
Wow.
So so if you have a will, you can pull up the will and see what's on there. Which most of the time no one cares. Someone might care, especially if someone owes them money or is just a nosy person.
Well, I'm thinking it's fruitful for scam artists,
Yep,
perhaps.
it's
Yeah.
fear for scam artists, and also when you don't have a will and stuff like that, you have to disclose what assets you have. So someone now knows someone died without a will, but they had $1 million. So they might pretend to have a creditor claim. They might do other things. And one thing you fascinatingly found a lot, I find a lot, is that real estate investors, people who are trying to get, it's like you will be blown up with like 100 calls from people being, I'll buy your house for cash. And I was
I'll give
like,
you
I'm good.
150,000 on your $500,000 house.
Exactly. And
Yeah.
there's a general rule that if anyone's calling you to buy your house, they aren't doing it to help you. So,
Yeah.
so there's a lot of things like that that'll come up where you'll just be barraged by various people just contacting you. So it's not just it's like aggressively public.
Yes.
Yeah,
Yes, I can see that.
yeah.
So, what are some of the tools and strategies that someone can use to avoid this probate situation entirely?
Yeah, so there's a few non-probate tools. The easiest ones are for certain assets. You may want to set up a trust, where you fund a trust. You put your assets into the trust, and then upon one's death, that distributes out. But even for simpler estates, there's a lot of things you can do that are free. Even like you have a bank account, you can name what's called a payable on death beneficiary, where you say, "Hey, if I die, I wanted to go to this person or people." Insurance policies make sure to list beneficiaries. Retirement accounts make sure to list your beneficiaries correctly. Pieces of real property. Georgia recently, almost a year ago, we're like a late state, it just has a transfer and death deed that you can now
Nice.
automatically transfer your deed to another person. It's probably called like a ladybird deed, but there's a lot of strategies like that where you can automatically transfer things to people outside of probate, which are a lot more cost effective. So while you still might file the will with the court, if you have a will, I still recommend filing with the court. But you hopefully you don't actually have to go through the whole probate process to be actually able to manage
Right.
the estate or do things.
Hopefully it's an empty will
Exactly. It's
by
just
the
there
time
for
it gets there.
decoration. Um,
Yeah.
and one will I talk about like, a lot is like Michael Jackson. You could Google his will. He has what's called a pour over will, which says everything goes into my trust. So we know no other information about his assets other than he has a trust somewhere that's holding the assets. And because he's a celebrity, the court sealed his trust. So we know nothing about his assets. But he does have like celebrities named as guardians of his children. I think it had like Diana Ross and some other people. It's a very fascinating will showing who he knows. But nonetheless, it does not put his business out there, and that's the
Yeah.
gold standard of the wills. But other wills are not as great. And if you have no will, your business will very much be out there.
Oh my goodness. So, what types of assets can typically bypass probate automatically?
So anything that's jointly owned with the right of survivorship. So if you have two owners on it, so right of survivorship ownership is usually automatic with bank accounts. So if you share ownership with a bank account with another person, like a spouse, a parent, or something like that, it automatically goes to the surviving owner. And same for things like real estate. Um, Everything else you can pretty much make it go without probate. You're going to have to make an overt step, like filling out a beneficiary form, um, setting it so that it goes into the trust, or if it's a business, transferring your shares of the business into the trust. So I can't think of anything out of my mind that you can't make go into some kind of probate avoidance vehicle. So you have art, you can update the title, you can transfer your tangible personal objects like um my phone, my pens. I can assign all my personal property into the trust to avoid probate. There's really nothing I can think of is that you can't get to someone outside of probate. You just have to potentially be creative or fill out some paperwork for the most part.
Okay.
So talk with your attorney. Don't be totally creative. Don't be creative on your own. Yeah.
Absolutely. So, when it comes to owning property jointly, say you put a spouse or a child on it, um, what are some of the pros and cons to that choice, and
Oh,
how does
sure.
that affect probate?
The pro is that it does avoid probate at the first death. So the con is if you have a more sophisticated plan or intention, it might not happen. So let's say someone has a blended family. So let's say husband and wife in this example, they both had children from prior marriages. And they buy a house, it's a joint tenancy with right of survivorship, so both names are on the house. The intention may have been is at the death of the second spouse, the house gets sold and goes half to spouse A's kids and half to spouse B's kids. But what would happen without doing anything is that at the death of spouse A, spouse B becomes a sole owner, and if spouse B does not do any affirmative estate planning, spouse B's kids get the whole thing, and spouse A's kids get cut out, and spouse A's kids might not be happy about that.
Yeah.
Especially if it was the intention. It might be less about the money than about being forgotten about. So
Yeah, well, and it might not even be forgotten about, right? Because we don't think that we might die at the same time or near the same time as our spouse, right?
yeah,
And so if you die and then the wife survives you by hours or days,
even
right?
yeah, yeah. The plane could go down. You could have a car accident or
Yeah.
something with a
And
silent.
it could that could accidentally happen through no fault of the surviving spouse because they couldn't.
Yeah, and
Yeah.
a lot of things could yeah. There's always other scenarios like spouse. It's pretty common, depressingly, that if someone gets ill, like a terminal illness, the caretaking spouse often gets sick themselves, or the toll of caretaking. So you could have a scenario where spouse A was spouse B's caretaker, and spouse B is not even able to write a will now. By
Yeah.
the time spouse A dies, they might be incapacitated. So they're now kind of stuck in a bad situation where not even spouse B's kids, but maybe Medicaid comes and takes the house because
Yeah.
it wasn't properly like structured. So there's a lot of scenarios that not having well it might avoid probate doesn't avoid the overall issue.
Which is that it doesn't go the way you wanted it
Doesn't
to.
go the way you want it. Yeah, exactly.
So I think you've answered the question that we can, in fact, completely avoid probate if we want to,
Yeah. You have to
with
be
or
strategic.
without a trust.
Yeah.
But why would we want to go for the trust?
You want to go for a trust because most people's wishes are one more granular than face value. Like you wanted to go to person B, but you also then want to go, what's the next step about that? What happens if person B dies, or do you want something more sophisticated? But
Yeah.
also, what who are people be like are your benefit do you like if you're a married couple in your 30s with two young children, like obviously if one spouse passed you want the other spouse to have it for their lifetimes, but what if something happened and you ended up leaving it to young children? How do you want it to be structured now? So you can thoughtfully decide, hey, I want my wife's sister to now move into the house and take care of the kids there, so she lives there rent free and Shanks are taking care of the kids. You got lots of different scenarios, but you could thoughtfully think out what the process would look like.
Yeah.
Additionally, you can plan for your incapacity. You can most people, a lot of people who have a disease or something like that, well, we can guarantee most all of us will die. We don't know how many of us will be incapacitated, not able to manage their affairs. So you have that issue as well, as far as if I have dementia, how do I want my property to be managed? If it's in a trust, you can designate a person who can manage that for you. And that, as well as Medicaid planning, special needs planning, stuff like that. Like we don't want to think of ourselves as getting injured, being unable to work. We can put together a strategy just in case.
Yeah.
And 99% of the time, that just in case never happens. But if that does happen, you will be extremely grateful that you had that plan in place, and so everyone else
Exactly.
around you, because they won't have to.
You don't have to scramble and figure
Yeah,
it out as you're going
exactly.
down the road. So
And it'll be
what are
protected for them in all likelihood, so they'll be like, hey, at least we don't have to worry about Medicaid.
Yeah, exactly. So what are some of the most common mistakes that unintentionally will force an estate into probate?
So not funding your trust. So if you have a house and you don't your attorney doesn't deed it into the trust for you, that's one thing. And usually when working with us, we will put your current property in trust. But if you then buy a house next year and you don't tell me about it when I call you at the end of the year saying, hey, has anything happened? That property might be probated to get it into the trust. Or if you get married subsequent to your estate plan, they may, let's say you sign a will, sign a trust, and you get married a year later, 5 years later, but you don't update your attorney about that. It may create some complications that force some of that back into probate, especially
Yeah.
if assets in like a community property state. This is not an issue in Georgia as much, but if it's like in Texas or other community property states, you may have more complicated issues because a lot of clients do own properties in multiple states. Um, Same for things like estate taxes, things like that you may not have anticipated having to pay. Putting in a trust often avoids it, but there's a lot of situations where you want to really kind of keep up to date on it so that nothing goes to probate. Like open a new bank account, buy a new life insurance policy. You want to make sure those things have roots to a beneficiary.
Well, that's been very helpful information you shared with us today.
Thank you.
And that's it for today's conversation. To connect with Stephen or learn more about estate and family law in Georgia, head to scriberlaw.com. If you found this useful, take a moment to subscribe, leave a review, or share the show with someone who could use clear, trustworthy legal advice. And we'll be back with more real world advice to help you plan ahead, protect your loved ones, and move forward with confidence in the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.